Hello, my name is Conor Duff and I am the FE1 Company Law Lecturer here at City Colleges. This is your night before recording video, which is accompanied by a brief set of notes that have been uploaded alongside this video. What I want to do is to cover some of the past papers and to look at some of the topics that have arisen in the company law exam over the years, and to also look at some last minute revision tips for your upcoming company law exam. The last paper for company law was very, very good, and students would have been very, very happy with some of the topics that were that arose on the paper, such as the anticipated topic, which was minority protection, which we predicted with our students here in City Colleges for the upcoming paper itself. So, as some of you know, at this stage in preparation for your exam, there are some challenges with the company law paper itself. The first challenge, I would say, with this subject is that the case law can be somewhat convoluted and complicated, and sometimes students find it hard to navigate their way through some of the case law for this subject. The important thing to remember for the exam is all that students are expected to rehearse in the exam and to recite is the ratio of the decision. That's really the important part that you need to focus on for the company law exam. The background detail and the facts, whilst it is important for you to kind of understand the background and the operation of the topic, that's less so important for your exam. It's important that students just focus on the ratio of the decision. There's also a very, very broad scope of material that students are expected to know. If you've looked at the syllabus on the Law Society website for this subject, it's very, very broad and quite dense in terms of the amount of material that students are required to know. So it is important that students have a very clear understanding of the past papers that arise in this subject. They know the types of topics that the examiner examines on, and you will see that there are very clear trends that arise from going through the past papers. So important that students understand the past papers, they've gone through the examiner's reports, which are really, really generous, and that they understand the topics that are highly predictable and that come up quite a lot. The other point as well is that the problem questions tend to be quite lengthy, so it is important that when you are in the exam you know the material and the information that you're looking for and you're able to identify it quite quickly. I've broken down the syllabus here very, very broadly in terms of how you should revise for this exam, starting with the birth of the company through to the life of the company and then finally the death of the company. That's how you should really revise now at this stage and use your mind maps for the really examinable topics that come up time and time again for this exam. So you see the breakdown there from the birth through to the life of the company and then finally the death of the company. And you will see across the papers there's quite a wide spread of those topics coming up in the papers. I said to my students for company law that the October papers tend to hold a resemblance and the March papers tend to hold a resemblance to one another, and oftentimes we see the examiner replicating very, very similar problem questions again and again, namely changing the names perhaps of some the individuals and problem questions, but there is some trends there. Now, while speaking of the last paper, there were one or two surprises. I think the biggest surprise for students in the last paper was the question on the restoration of a company to the register if it's been struck off. Now, that topic had not come up for many, many years, and students may have just had skeletal notes on that question itself. But for those of you who did attempt, or for those students who did attempt it rather, it was a very, very straightforward and easy question that is largely provided under the statutory provisions, and there's only a couple of cases, and I imagine that of the students who did attempt it, which I imagine would have been very few, they would have done quite well. Now, the other important thing I should flag at this stage is that the examiner in the past has examined a particular topic that may not have been popularly answered, but then will examine it again in the next paper, and it's a real sign from the examiner that this topic will be examined in the future. So although unlikely, I think it is, it shouldn't be completely off your radar for that topic to come up again in your upcoming paper. There's a breakdown there of the Companies Act of 2014, and in bold the topics that are really examinable on your syllabus. I would say the left-hand column there would contain the most examinable portions of the Act. And you are, of course, permitted to bring in a copy of the Companies Act of 2014 in your exam. You are permitted to underline, highlight and tabulate the legislation. You're just not allowed to write anything on the legislation. And particularly with company law, given the amount of sections and the large nature of the legislation, it's really crucial that you familiarise yourselves with the legislation in advance of going into this exam. This is not an exam that you can open up the Companies Act for the first time the night before the morning of the exam. You really need to now familiarise yourselves with the legislation and make sure that you're able to work your way through it and know what you're looking for. So over the next couple of slides, I provide a breakdown of the various topics that have come up in the last number of papers. If we look at the March 2024 paper, there were questions on fixed and floating charges, corporate governance and directors' duties, separate legal personality, directors' duties, minority protection, striking off and restoration, that was the topic that came as a surprise to many students, restriction of directors, which was an essay question, very lovely question, very popular question over the last number of papers. I imagine students would have been very, very well prepared for that topic, and it's certainly a favourite for your examiner. And then the enforcement of charges as well, the typical question that comes up on that topic. October 2023, there were questions on section 158, which is the table A requirements. Question 2 was on share transfer, and again, that's something that I wouldn't be surprised to come up in your exam. There's the typical problem question about 3 family members, one living abroad and wants to transfer their shares to somebody else, and you're asked to advise the 2 directors as to whether they have to accept the new shareholder. And students will be very, very well prepared for that question, and all of the various case law on that question, and it's just a very nice problem question that's repeated time and time again, and students should have no difficulty with it. Question 3 then was on substantial transactions and loan to directors. 4 was on the essay question on ultra vires, again a topic that students will be very, very well prepared for. The essay question on restriction again came up in the October paper, and it could very well arise in your paper again, making it the 3rd or 4th time in a row. Disregarding separate legal personality, that was a nice problem question about holdco and subco, and the answer to the question was obviously in respect to disregarding separate legal personality, and students would have referred to the doctrine of agency and the single economic entity principle as well. Section 31 of the Companies Act 2014 was then examined under question 7. This was an essay question that asked students to discuss the Section 31 contract, which is of a most sacred character and nature. As you will recall, this is the contract between members of a company, that it's a statutory form of contract, that they will act in the best interest of the company and comply with the Companies Act and the constitution of the company. And students would be very, very well prepared for that question. And then question 8 was on directors' duties. So over the next course of slides, I go through some of the other past papers that have come up in this exam. In terms of hot topics, it's very, very hard to predict, obviously, what's coming up in your exam. There's one I left out here, which is probably ultra vires, which could potentially come up as well. But other favourite topics would be minority protection. I know that came up in the last paper. I would not be surprised to see it again. Charges and corporate borrowing, which probably should be together there. Directors' duties I've put in red. I would really anticipate a question on that. Probably my biggest prediction, I would say, would be winding up. I think it's been a long time since winding up has arisen on your exam, and in particular the court ordered winding up for inability to pay debts. There's lots of case law there, there's lots of things to examine on. The examiner has examined it in the past, so I will have marked that in bold and underlined because I think it is highly probable to come up in your upcoming paper. Restriction, again, I know it's been examined a number of times in all of the last papers, but I still think it can't be ruled out. Section 158, corporate governance, and then also the 31 contract. The classic question on share transfer, again, I would not be surprised to see the classic HoldCo and SubCo problem-based question on share transfer and the refusal of directors to transfer shares to an individual. And then examinership I'm going to put as my wild card, and I've been saying this for years, but I have it there as a wild card because it hasn't come up for some time, and I think it's due a run, and there's some recent case law as well. In particular, I think there's a decision by Mr. Justice Michael Quinn in Mac Interiors where he summarises the relevant principles for examinership. So I wouldn't be surprised to see it. It is a wild card prediction, wouldn't be as strong as Winding Up or some of the others, but I do think it's most certainly due a run in your upcoming paper. The examiner has constantly repeated in his feedback that students are repeating long descriptions of irrelevant material regarding case law. As I mentioned at the very outset, it is important that students are discussing the ratio of the decision. They're getting to the point. They're identifying the key legal points that can be identified from the judgment of the court, and the students are not going into unnecessary background information regarding the case law. And then also, and I always stress this to my company students, the importance of your discussion of the application of the law. That really is important. It's something that the examiner consistently refers to throughout his examiner reports, that students really need to apply the law to the facts of the problem question. For problem-based questions, students should really use the ILAC structure. Essay questions, I always say FLQ, factor in the language of the question in your answer. That's really important to ensure that you're staying relevant. There's a nice good mix with the company paper between problem and essay questions, so don't be afraid of the essay questions. The other point I would say to you is every time you refer to a case or a statutory provision, you should really highlight it, and if you're doing it online, put the case and section in bold and underline it. The famous question I'm always asked, how many cases do I need to refer to? The answer is as many cases as you can, okay, that are relevant. Of course, the important thing is to answer all 5 questions in your exam, and generally if you're doing it in person, to start with your best answer. I know that's not an option online, but that's always been the age-old advice given to you. The other bit of feedback is, and again it's age-old advice, but to read the question twice. You know, I've looked at papers with my students where students spend a considerable amount of time discussing irrelevant issues that you're not being asked to advise on. This examiner is generous that in the end of the problem question, or whatever the case may be, he will tell you expressly what he is looking for in your answer. So ensure that you're constraining your answer to what you're asked to advise on. And then this is I just thought I would share with you some of the kind of popular questions from the March 2023 paper. I know it was a while back, but sometimes if you go back sufficiently, you may come across a question that could come up in your exam paper. Question 2, March 2023, was a director's duties question with conflict of interest. And again, this is one that has been recycled for a considerable period of time. Students would identify section 228 of the director's duties, the duty to act independently, to avoid conflict of interest, to act with due skill, care and diligence, to act in the best interest of the company, and the fiduciary duty of loyalty. So students would be very well prepared for this question. This is a question that's favoured by your examiner, and students would have sufficient case law there as well for that one. This again has been a favourite of your examiner, which is an essay question on restriction, and to discuss the defence of acting honestly and responsibly that's open to a director facing a restriction application. And students would know ample case law regarding this particular topic. Will be able to refer to the statutory provision of 819 and would spend some time discussing the mandatory nature of the wording, okay? The mandatory nature of the wording, which is that the court shall make the order unless the court is satisfied that the director has acted honestly and responsibly in relation to the conduct of the affairs of the company, that the director has cooperated with the liquidator, and that it would not be just and equitable to make the order. So students would be very well positioned to really tease out the detail of section 819. Question 7, again, this is a prediction for what I think is going to be an essay question on your paper, which is the causes of crystallization. I think this is really due a run in your upcoming paper, and students again would be very, very well prepared for this topic coming up as an essay question. This hasn't come up since March 2023, the topic of receivership. You know, it could very well come up in your paper, and this is a nice problem question, again has been recycled time and time again, asking students to discuss the powers and the duties of a receiver. So look out for a receivership question as well. So thank you all very much for your attention, and thank you for watching the lecture, and I hope you found it to be helpful, the short video, in anticipation of your upcoming exam. Just remember to really focus on structure and applying the law to the facts of the problem question. It's really, really important. But thank you very much for your attention, and the very best of luck in your upcoming FE1 company law exam. Thank you.